one time.
I know what you're saying, Corp, but I'm telling you that's not even me. I don't even.
Wait a minute.
How come I haven't met you yet?
I came to your house today. You didn't want to talk to me.
Oh, I didn't. No, I was asleep on that. I swear. If I would have known you were there to talk to me, I
I
would
was
have
banging on your door for like 25 minutes.
Oh. I've been feeling sick. I was on a lot of sleeping medicine.
Everyone on this scene with the body cameras rolling.
Hi. Hey, how are you?
How's it feel to be going back to jail?
Oh, well, you know, since you guys want to do any kind of reporting, make sure that you put on YouTube after we multiple times tried to take down a YouTube channel that was hacked and the $10,000 that was in my account on my YouTube channel was taken, and YouTube refused to take down the channel. Probation then put a warrant out for my arrest for failing to take down the channel that has been up for multiple years, and we've tried multiple times, including my attorney, to take down off of YouTube.
Jeremy, what's pretty easy to delete an account? Why can't you just follow the law?
Well, because somebody hacked that account, changed the username, you changed the passwords, changed all the information, and then took my money. And now, because it's me, when I go to my own account, that is no longer, I have no longer access to, I can't even shut it down. I can't even use it. I can't even post on it. I can't even shut it down. And I explained that to probation multiple times. We even showed them the proof, and they put a warrant out for my arrest for not taking down the channel, even though YouTube refuses to do it.
Jeremy, I hear you were live streaming during the arrest. Why do you do this for all the attention?
Say that again, I'm sorry?
I hear you were live streaming during this arrest. Why? Why do you do this?
I was live
Do
streaming?
you do this for the attention?
No.
How does it feel to be known as the notorious fake cop?
Fake? Huh. Well, that's great. And I wasn't live streaming, so I don't even think anything. You guys, your lives are too bright. Well, watch your steps.
You're calling it a fake cop.
Oh, you're going back to the
I need units now. Sergeant?
I'm a little deputied out right now, with all due respect.
You too,
thank you.
Mr. Ledan, good morning.
Good morning, Your Honor. How are you?
I'm good. What do you have on the docket today?
I've got Jeremy Dewitte, Your Honor.
Where do you stand preparing Mr. DeWitte's cases?
Well, Your Honor, I believe we've had a change in prosecutors, and I think it might be fruitful if we could plea conference this with Your Honor. Would there be a way to do that on Thursday, or is there another date that would be better for the court?
Well, shockingly, I know you're going to be stunned to hear this, Mr. Ledan. A lot of things didn't get done in December, so we're doing double work in January.
Heard, yes.
So if I don't do a VOP hearing on the 26th, then potentially we can have a conversation. What I don't know is how comfortable the state's going to be about plea conferencing Mr. DeWitte on the 26th. So, but if you want to come down here, we can have that conversation. I think the challenge is, if I remember correctly, didn't Mr. DeWitte get departure sentences on the front end?
He did, yes. There was a stipulated downward departure, and it was split sentence. So he did some DOC time followed by the balance of the sentence.
Your Honor, additional charges were also filed last week on Mr. Dewitte as well, which will probably lead to another updated or amended violation of probation as well.
So my understanding is there's already an amended file based on some things that took place in Osceola County when they were attempting to serve the original VOP warrant. Are you telling me on top of those, there's yet more charges filed?
Yes, they filed more charges. Our office filed more charges, I believe last Thursday or Friday, Your Honor.
Also related to events in Osceola County or unrelated?
These are unrelated.
Mr. Ledan, are you aware that your client's acquiring more charges?
I'm aware that there are warrants for his arrest from charges that were, I believe, predating his sentence in this case, and I haven't seen anything or been hired on that, but it was an agreement that we had with the state at the time that we accepted this agreement that they were not to prosecute any other cases arising out of their investigation. So I need to see what those charges are to determine whether we've got an argument to be made there.
Okay. So my suspicion is we're not going to have a very productive conversation this Thursday. If you want to come and have the conversation, if I have time, we can have that conversation. Otherwise, I was going to reset you to February 20th so you can figure out what the legal posture is, whether there in fact is a basis to dismiss the violations or move to dismiss the new charges that have just been filed, which I understand. If there was such an agreement, then obviously you need to represent your client and litigate that issue. So if you want to come on at this point, I just don't know how many hearings I'm going to do Thursday. Right now I've got one set, and I've got stuff set later in the morning, so I don't know if I'm going to have another set, whether I'm going to have any time to talk to you.
That's fair. This is the only thing miraculously that I've got scheduled on Thursday, so I don't mind coming and being a fly on the wall and waiting to see what happens.
Okay. So let's do this. Rob, can we order, do you want your client here?
I think it would be important for him to be there if we were to have any kind of conversation about it.
Let's order Jeremy Dewitte for Thursday, and I'll just see if I can get to him or not.
That works for me, Your Honor. Appreciate it.
All right. So I'll call that a plea conference Thursday at 9 a.m., and we'll see whether there's actually time to do it or not. Is that it,
Sounds
Mr.
good, Your
Ledan?
Honor.
Mr. Ledan, is that it?
Huh?
Go ahead.
Postal 199 out of Orange County on a Jeremy Charles Dewitte, white male, date of birth 2/10 of 1980, 5'11", 185, murder, Auburn, Hazel. It's going to be a reference to violation of probation, falsely impersonating an officer, no bond. It does advise a violent felony offender, special concern, history of violence, and a 37 offender gives the impression of being a law enforcement officer performing traffic enforcement and violating traffic statutes and signal 29. He's also showing as a 37 offender for a DLE and first fulfillment, and he's showing also to inmate release status, reference to impersonating an LEO with supervision to follow, showing on probation or supervised release status, special non-violent felony offender, special concern, showing special convictions as 37 offender, curfew 2000 to 0600, submissive search, no driving deal, result suspended, performed installment, showing 1015 history reference, impersonating LEO, and failure to register as required, 1048.
26, thank you, man. I appreciate it. Today, back up.
Huh? Stay on your horn. You got movers. Stay on your
Tell
horn.
about it later. Let's go ahead and call the Dewitte cases. Do you want my page?
For just a second, so I can solve it, I'm sorry. And then they disappear. State of Florida versus Jeremy Charles Dewitte, 2020 CF 4466, 2019 CF 12733. State.
What's the segment on behalf of the state, Your Honor?
Defense.
Amir Ledan on behalf of Mr. Dewitte, who's in the jury box.
Do you anticipate him talking to the court today?
Probably.
Let's go ahead and swear him in.
Please raise your right hand. Do you solemnly swear that the testimony you shall give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Good morning, sir. Tell me your name and your date of birth.
Jeremy Charles Dewitte, 21080, Your Honor.
Mr. Dewitte, you previously entered pleas on these two cases. My recollection, I haven't pulled up the score sheet recently, is you were sentenced to something called a departure sentence. So it was a period of time in Department of Corrections followed by a period of time on supervision. It has now been alleged that in each case you violated your probation. Your attorney asked if we could bring you over today and engage in what he referred to as a plea conference. So, so Mr. Liddell, I'll yield the floor to you. What do you want to tell the court and or what do you want to ask the court?
Yes, Your Honor. I appreciate the court's time this morning, and I'm grateful that your other hearings fell off so we can actually do this. The essence of the violations as they stood, and there may be things I don't know yet because I was told there was an amended coming my way. I don't think I've received it yet. But Reader's Digest version of events is my client entered a plea that required him to divest himself of his business, Metro State Vehicle Protective Services. As part of that, he was to remove all insignia and the appurtenances to said business, but he was to be given 60 days from the date of his release to do that. There was a lot of back and forth with probation about that, as well as whether he was even permitted to return to the home because the home had vehicles on property that had those things. And so by way of background, this did not begin as an easy transition from DOC into his probationary sentence. And in fact, for some reason, his original probation officer was of the opinion that he was on sex offender probation, which was also inaccurate, and all those things had to be hashed out. So while it's Mr. Dewitte's obligation to comply with his sentence, I think there were some road bumps that were perhaps unnecessarily in the way that may have created some tension between he and his probation officer. So that's really more background than anything. The technical violations that are alleged are that he did not do those things. I believe, based on my extensive review of the evidence and information that we have available to us, that I'd be able to present to the court's satisfaction and to the state's satisfaction, that Mr. Dewitte endeavored to do all of the things required of him to facilitate the sentence as it was intended, and that he was thwarted by certain things that were beyond his control. Such as not having access to the logins and whatnot to facilitate removing things from the internet. So I believe those things can all be relatively easily established for the court's satisfaction. When it came to light that Mr. Dewitte had a violation of this sort pending, I called upon Your Honor in open court, and you were kind enough to hear me out with the prior state attorney present, whether you'd be willing and amenable to recall the warrant and allow Mr. Dewitte to appear voluntarily on this violation, and Your Honor respectfully declined to do that. Whereafter I communicated that to Mr. Dewitte, and he was ultimately taken into custody on the violation. They've since, I think, amended the violation to include the fact that he wasn't answering the phone and answering the door and whatnot. I would, as an officer of the court, tell you that was during the period of time that I was incommunicado with him in an effort to try to stave off him being arrested and losing his rather significant deposit that he had made on the trucking school that he was enrolled in and participating in as a means of trying to provide for his family while on probation. They knew his whereabouts. He's on a GPS. It was not, leaving the jurisdiction of the court or doing things of that sort. He wasn't, trying to sever ties with probation. We were trying to work through the process together. So for what it's worth, that's where we are. Now, I know that there are new charges filed, and as I indicated on Monday, I believe that there's a issue with that, but I may be wrong. I don't know what I don't know, and I haven't taken on those cases, and I don't have the discovery, but the timing surely would suggest that it would be perhaps problematic. So what aggravates me in this case is that, there are things that Mr. Dewitte likely could have done a little more cleanly on his end, but I don't know that he did anything with the intention or the purpose of violating probation. And I feel like sometimes Mr. Dewitte is my, gangster that can't be convicted of a crime, so they come after him for tax evasion and they try to stick him with, these technical things. And so,
is it the defense to the crime of tax evasion that I'm a gangster and they're only doing this because they can't get me on bootlegging and
No.
Murder and all these other things?
No, it is certainly not. No, and the prosecution has every right to pursue whatever the law allows them to pursue.
So, Mr. Ledan, on January 23rd, there was an amended affidavit filed, and the amended affidavit that I see, there are a number of allegations in regards to vehicle registration.
Right.
In regards to his status as a sex offender. There's some issues with his electronic monitoring. So it does not appear, in fact, based on what I quickly looked at, that they're now attempting to resurrect charges that were previously agreed to be null prost or not filed in return for his plea on the cases before the court.
Okay.
So, and I think that puts the case in a different posture at this point in time. I understood the points you made. It would have been a very interesting violation of probation hearing if the only issue before the court was closing the YouTuber channel or not. But now it appears to the court that the state's going to proceed forward and attempt to establish that he committed multiple offenses in regards to not complying with his statutory obligation as a sex offender, which would, in my mind, your client has a couple hurdles. Number one, he negotiated a resolution where he pled to several cases. He had a number of cases dropped.
Right.
Which you've explained to me before, and I understand that your position as attorney and his position as the defendant was these were bad cases. They weren't going to win these cases anyways, but they were out there. So, we made this decision to give up our right to go to trial and prove on all these cases, or establish on all these cases the state can't prove my client's guilt. And he took a departure sentence in return.
We're not going to win the battle and lose the war, basically.
So when he comes back before the court, that was the bargain he struck.
Right.
And the allegation is he hasn't lived up to his end of the bargain. So normally, as I evaluate these things, understanding that every case is unique, every case I can't let what I normally do or my policy drive my decisions, but my starting point in analyzing the case is, well, you pled to these charges, your recommended sentence was X, you didn't get X, you got an opportunity to prove that you didn't need to be locked up for the full length of time, and now there's back evidence that that was an incorrect assertion.
Right.
So normally my starting point is, what is his guideline sentence now? He had his departure, it didn't work out, it's time to do that. There are cases, I'm sure we could go back and find cases where I continued a departure sentence on a violation after I heard all the evidence. Or it was negotiated and the lawyers presented it to me and I didn't have any heartburn about it. But there are other cases I'm sure we can find where I did have heartburn about it, or I said, it's time for him to get the sentence that the law said he was supposed to get way back when he entered his plea.
Right.
Given the allegations that there are new criminal offenses, typically, in my mind, that's an aggravating factor. And so if that aggravating factor is not outweighed by mitigating evidence, then it might not be what the recommended sentence is. It might be what I think the sentence is. And some people feel that my perception of what appropriate sentences are may not be simpatico with what other judges' feelings on sentence are. But I don't know. I don't go in other courtrooms and watch judges impose sentences. So I don't know. Maybe I'm actually the nicest guy in town. I'm a big Stay Puft Marshmallow. And, people are happy to find out that I've got their case. I just don't know. So, but that's where he stands at this point. I'm not really sure. Given the January 23rd amended affidavit, it's just way too premature to have a discussion about what the outcome might look like if he were to admit he violated.
That's fair. Let me ask the court's kind of thoughts on this, because you've always been very candid, and that's why I wanted to have this opportunity. His father-in-law just passed away, and his wife has traveled to tend to the family's needs for that purpose. As I said, he had signed up for this trucking school. I believe he's probably lost his deposit, although I don't know. My understanding of these failure to register charges at first blush, and I've seen about this much of it. I would be very surprised if this client did anything that would be contrary to the sex offender registration. He knows it better than I do. The cars that are at issue are not new vehicles. They're vehicles that have been within the family of vehicles, either through Metro State or personally, that have been in existence for years and known by the government for years. So it may be a hyper-technicality, I don't know, and it may be a correct hyper-technicality, but I would venture that even in light of the court's opinion of downward appropriateness and reinstating or whatnot, that if that was to be the case, you might feel a little more simpatico to something other than, putting someone in prison who's otherwise doing the things they need to do and able to integrate back into society. So my thought is there a mechanism for me, not today, but to come back before the court perhaps and present some testimony and evidence, no doubt over the state's objection, to release him on a conditional release of some kind while we sort through all of the things that have to be yet to be determined. I know he's a violent felony offender of special concern as it relates to past conduct, but in my experience with his cases in the past, he has been granted release. I think we talked about what the statute allows, but I think there's a mechanism for conditional release. I could be wrong, but that would allow us to work through this while he's out of custody.
Your Honor, can I add some information to the court? I talked to Mr. Lanadan about this. I spoke to probation and Osceola. There is another admitted violation coming within the next 2 weeks. So he is getting new law charges again in 2 weeks from now from Osceola, in addition to the charges that were just filed, in addition to the charges that were filed in Orange County recently as well.
So, Mr. Lanadan, in regards to release prior to disposition, my reading of the anti-murder statute is, again, there's 3 ways that you can be classified a violent felony offender of special concern. Number 1, you are on supervision for a qualifying offense. Number 2, you're on supervision and it's alleged you've committed a qualifying offense. Or you're on supervision and you previously have been convicted of a qualifying offense. Any one of those gets you the violent felony offender special concern designation. Additionally, the way I read the statute is that the only way the defendant can be released is upon the completion of a danger hearing, and a danger hearing is only conducted after the court has adjudicated the defendant in violation. In other words, it's basically another step that the court's required to do. Again, I think if you go back and look at the history of the anti-murder statute and the high-profile cases that I perceive drove the legislature to pass it, it was circumstances where lawyers were coming to judges and maybe they had a special relationship with the judge and they were signing VOP dismissals in chambers without the opportunity for the state to be heard. I suspect the state was actually complicit, but the problem was no one knew because they weren't on the record. And or people being found in violation and just being kicked back out because, again, maybe there was a special relationship between the lawyers and the judge and there was a wink and a nod. So the legislature decided can't let judges have discretion in this situation, and so they wrote the anti-murder statute. Right. I just follow the law. So my reading of the law, and I know when I first cycled back to criminal, I was getting these bond hearings where the lawyers said, well, we want to have a danger hearing, and if he's not a danger, you can post bond, and the state was in agreement that we could do that. You can probably find my signature on a couple. And then I went back and read the statute and realized that either the lawyers just happened to be wrong or the lawyers pulled the wool down over my eyes. I don't know which one it was, but I'm very convinced, having read it on multiple occasions, politely argued with multiple lawyers that, no, I can't do this. And the fact that the system's done something in the past doesn't necessarily mean it was right.
Right.
So, just like the things that led to the anti-murder statute probably weren't right, and provoked the legislature to respond and take away my discretion. Right. So I don't think because he's violent felony offender of special concern I can do anything until I determine whether he's willfully violated probation or not. So
I'm getting the cart before the horse. Yeah.
I don't blame you. You're advocating for your client. I just don't think I can give you any of the relief your client's hoping to get given his status.
Right.
So, do we have a future VOP status date for Mr. Dewitte?
We don't have any dates, Judge. We kept this on today for that purpose so we could try to calendar things, and I wanted him present to understand kind of what's going on. So,
Your Honor, can I put the current offer on the record for the defendant's purposes?
Sure.
The current offer is the lowest permissible sentence, which is 69.07 months, Department of Corrections, but I'll double check that date or that amount.
And are you making that offer without knowing what the next amended affidavit of violations will tell you?
I took it to the probation officer, and he informed me of what it is.
Okay.
And I'm comfortable at this time making that offer. So it's 69.07 months, Department of Corrections. And I sent an updated score sheet to defense this morning. And Mr. Lydia let me know if he did not receive the second amended violation of probation. It was sent to you on the 25th.
I didn't see it, but that doesn't mean I don't have it. So I want to tell you the wrong thing.
There should be 2 documents. So let me know if you don't, and I'll resend it again. So.
And I did receive, I haven't had a chance to show Mr. DeWitt, but I did advise him. I did receive the sentencing score sheet today, showing the one I'm looking at says 69.08. Is that the right one? Because I know there were 2 sent.
And this is the global score sheet, Your Honor. Now, it's 69.07 is the lowest permissible sentence.
Okay. I don't know where that 100th is.
All right. Well, let's do this. Mr. Ledan, it's unlikely that you're going to be filling out an admission form in the next 5 minutes, correct?
I will not be doing that.
Okay.
I'm not rejecting the offer. I'm not in a position to reject the offer, but I'm not.
I've got other matters.
Right.
So let's do this. Given the fact that there's yet another amended coming, I was going to suggest that we set this for the March 27th VOP status, March 30th hearing. That should give you enough time to continue to negotiate with the state, find out what the latest allegations are, and prepare any defenses.
I appreciate the time. The only challenge I have, other than Mr. DeWitt obviously having no desire to sit here that long, is I will not be in the state of Florida. That's my daughter's spring break, and I'll be out of town.
Okay.
Is there anything a couple of weeks earlier, or?
It's February 20th with February 23rd.
Okay. Knowing that may put me in the similar posture I'm in today, I'd still rather have that opportunity, Judge, if that's okay.
All right. If y'all tell me that there are a lot of moving parts, particularly since there's pending Osceola charges, and you need more time to see if y'all can resolve it short of a hearing, and that's not going to move my needle. I just, like I said, this amended affidavit, I think, has like 8 or 9 additional allegations in it. So
I'll have to review that with my client.
Maybe more than that.
Right.
I'm very sorry to interrupt, Your Honor.
Talk to your lawyer. Talk to your lawyer.
Can we get a reading of those? Because
I'll bring them to you.
Can I get a printout of these affidavits? Also?
I'll bring it to you.
Mr. DeWitt, that's a conversation for you to have with your lawyer, not a conversation to have with me, okay?
Yes, Your Honor.
All right. Mr. DeWitt will be returned to the Orange County Jail pending disposition of his violations or further order of the court. February 20th, status hearing February 23rd, hearing date. Although it sounds like if this is going to be a full hearing, we might need to set this off.
If it goes there, then certainly we'll need
Probably a full
a few
day.
hours of hearing time because we have witnesses to bring in.
Right.
And
Okay.
220 is at 9 a.m., correct?
Correct.
The status is also at 9 a.m.? I mean,
220 Typically, yes.
Okay.
Start the hearings, but the challenge is going to be usually the hearings I'm doing then are like the hour-long type hearings.
Right.
So.
Well, I'm sure we'll figure out on the 20th where we lie. We probably will
Okay.
pivot from there. Thank you, Judge, for this court's time.
Have a good day.
You as well.
Huh? Did he just say I won't get out?
Sergeant?
I know for a fact that wasn't me.
Okay.
All my guys have pepper balls.